Dun, 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 dun. YouTube. In the left corner, Bo Jiden. In the right corner, Trump.
W
Who,
bird.
who will be the final contender?
Big Mike.
So yeah, basically to run through it all and not spend all night on the subject. Everything they were talking about was unconstitutional besides the import tax on the Chinese stuff. What did he used a certain term?
Tariffs.
Yeah, that's constitutionally legal, and securing the border is constitutionally legal. Out of everything they said, everything they debated the whole time, besides them debating golf, which is retarded, but they, everything they mentioned was unconstitutional. They're like, oh, well, this is a point I made to you earlier and on Twitter. Each one said we made millions of jobs. It's like, well, how are they making millions of jobs unless they're violating the 10th Amendment, violating the 10th Square Mile Clause, and running on absolute communism, where the government controls the means of production. And then, so then there was them talking about all these wars. Oh, well, I did this and I did that, and it's like the unconstitutional thing is that Congress never waged war, so there can't be no war or delegation of troops. What else? All the health care. That's a violation of the 10th Amendment. Whenever the state has jurisdiction, the Fed cannot. Or if the Fed has jurisdiction, the state cannot. That's basically the 10th Amendment. So if and then they talked about the taxes, the rich. They're like, oh, we need to tax the rich more. And it's, well, technically the enumerations clause states that it must be enumerated, meaning divided by the whole population and evenly distributed for the tax.
Right. Wow. Yeah, that's important.
Yeah, and then the fact that if the state taxes the citizen, then the 10th Amendment kicks in and the Fed cannot. And so the state taxes are, because when the Fed taxes us, that's a direct excise tax.
Right.
And that's the Constitution strictly, it says Congress shall not pass any direct excise tax, I believe is the let me just look that up real quick. Clause. Okay, yeah, so fourth clause, article 1, section 9, clause 4. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directly taken.
Right.
So And then thus the supremacy clause, which states anything in conflict with the Constitution shall be notwithstanding, so the supreme law of the land.
So where was it or not was it the case in the Bill of Rights that any of these later amendments be added? Like,
well, they started adding them. I don't remember what the 11th one was or the 12th, but the 13th one.
It'd be interesting to speak to a constitutional lawyer or a constitutional historian and say, what happened back then when the first amendment after the Bill of Rights was passed? Like, what was the political pushback then? Because clearly they'd already, like you say, reached outside of the instrument. Like,
oh yeah, well, I would say that when they created the 14th Amendment, that's when the first violation.
Right.
So the 11th Amendment was made in 1794.
Right.
Restricts the ability of individuals to bring suit against states of which they are not citizens in. So that makes sense. So we couldn't sue like Wyoming or something. But let me see when the 14th and the 16th Amendment weren't too far away. 16th Amendment. Let's see. What's the date on that? It's funny because I'm okay. No, so the 16th Amendment was 1913, but the 14th was during the Civil War.
Right. So we got there then. So basically, when people were figuring out what to do with the slaves of all, forget the word slave, but figuring out what to do with the population, that's when all the conversations of how to add things in, it all become like, what do they call it, legalism?
Yeah. Okay. So the 15th Amendment was, that one's constitutional because it lets slaves vote, or lets. Damn, I'm stoned. Let's African Americans vote. But technically, they should have been held equal. They shouldn't have need to made an amendment to make them held equal because there's nothing in the Constitution that forbids them. It's hard to explain, but like, it's like the South would not like let it go because the South was full of a lot of those, the Knights of the Golden Circle, or I think it was called, a lot of different groups like that, especially B'nai B'rith. The South, a lot of the slave masters were B'nai B'rith.
Well, this reminds me again of what we're saying about Rome, where like at one point you've got an opportunity to use cash to buy some democracy in a way, but then if they change their mind and they're like, no, we need more slaves, it goes out the window. This is the problem of the whole democratic republic thing again, is you just start violating something that's supposed to be inviolate. You just stop fucking with it.
Hey y'all, how's it going? This is Chad Warren. I hope you're doing well today. This is Friday, 6/28/2004, 7:38 a.m. and I am just going to play a small bit of Clint the Third World Assassin over on YouTube, talking about how silly the debate was because we do not live under constitutional law. These Republicans are stupid and lying to you. They're even worse than the stupid left because they're supposed to know the law and defend it. But we haven't been living by constitutional law since forever, like the Civil War. Duke. Slavery in the United States, persons or property. R. Corrected Proof, Final 7/9/2012, SBI. Paul Finkelman. Did you know? The American Constitution does not mention slavery until 1865. Well, I guess I can have myself up here. Let me do that. I'll put it over here. I think I'll make it smaller. There you go. With the adoption of the 13th Amendment, which abolished the institution, I'll put this window up to make it better. Yet, the Constitution written in 1787 is riddled with provisions tied to slavery which protected it without naming it. The goal of this chapter is relatively modest: to examine how the U.S. Constitution and the Supreme Court understood what slavery was and how the court defined it. I begin by exploring how 17th century Englishmen in colonial Virginia developed a legal system to accommodate and perpetuate slavery within a common law regime that was essentially hostile to human bondage. That was the whole point, supposedly, of the American Revolution. Freedom! The colonial lawmakers had to develop rules to balance the tension between treating Africans and others as persons held to labor and as property owned by other people. This colonial background sets the stage for understanding how the framers at the Constitutional Convention in 1787 protected slavery in law. Next, I examine how the U.S. Supreme Court came to define slavery through its jurisprudence. A constant theme of this discussion is how the legal system balanced the dual status of slaves as people and as property. A. Slavery, the common law in colonial America. The Spanish and the Portuguese, who first settled the New World, had well-developed slave cultures at the time of the first voyage of Columbus in 1492. Not surprisingly, they brought concepts of slavery with them and quickly established the institution. Ironically, the first transatlantic slave trade went from west to east. This all goes back to these seafaring peoples like the Phoenicians. When Christopher Columbus sent 500 Carib Indians to Spain in 1495. They did not, of course, introduce slavery to the New World. Slavery could be found throughout Central and South America and flourished among the Maya, Inca, and Aztec. Take that, you people that hate white folks. In addition, various North American Indians held slaves, and some, like the Tlingit, were vigorous in capturing slaves from other nations. See entries on Maya, Aztec, Inca, and other native peoples in Paul Finkelman and Joseph C. Miller editions, the Macmillan Encyclopedia of World Slavery. Spaniards already held Turks, Arabs, Africans, and other slaves, and would initially enslave Indians in the New World. When the Indians died off in large numbers due to disease, overwork, and brutality, the Spanish brought Africans into their new colonies. In addition to experience with slaveholding, the Spanish and Portuguese legal culture, based on Roman law, allowed for the quick creation of not only slaveholding, but of a system of slavery. Roman law defined slavery as an institution of the law of nations, by which a person, what is the law of nations? A person is subjected to the dominion of another. According to Justinian, the principal distinction in the law of persons is that all men are either free or slaves. There is no third intermediate category in Roman law. At the beginning of the 16th century, slavery as an institution did not exist in France, and there was a long tradition of emancipating slaves who entered the country. But at the same time, there had always been some slaves in France, and France's legal culture provided some institutional support for slavery. France did not wholly adopt Roman law, since they were the Gauls, they were the barbarians at the gates once upon a time, but French lawyers and judges regularly turned to Roman law. France's code-based system of law also meant that legal change could be quickly accomplished. Concepts of slavery in Roman and canon law meant that the legal principles on which slavery was based were not entirely foreign to France. Thus, it was possible for French settlers to establish slavery in the early 17th century Caribbean, and for the government in Paris to regulate slavery in the colonies with the introduction of the Code Noir in 1685. Indeed, the Code Noir was created at the behest of the king, which illustrates how easily France accepted slavery as a legal concept. In 1716, French legislation explicitly allowed masters to bring slaves to France under some limited circumstances, even as it also provided for the freedom of slaves brought to the metropolis contrary to the law. These laws illustrate how smoothly France, a nation which prided itself on not having slaves, adapted to slavery. Its Roman civil and canon law traditions made these legal developments possible. Other continental powers, the Dutch, Swedes, and Danes, were likewise able to draw on Roman law traditions to establish slavery in their New World colonies, even though there was no slavery in the metropolis. Unlike other New World settlers, the English had neither a law of slavery nor a tradition of slavery. The English who arrived in Jamestown in 1607 came from a place where the legal institution of slavery was a relic of the past. Moreover, when the English came to Virginia, they saw themselves as potential liberators of the Indians and slaves. Yeah, that's a definite thing I would like to look into more, because my understanding is it was not the desire of the majority of people to massacre all the Indians. That was forced upon them, just like all the stuff we experience. Who were under the domination of the Spanish. Thus, slavery as a system of property ownership or labor exploitation was truly foreign to England. The English had nothing in their legal structure that recognized slavery or property in human beings. Eventually, England would make huge profits from the African trade and its sugar colonies. Members of the royal family would be among the first to invest their private money in the Royal Africa Company, thus profiting from the slave trade to the Americas. But in England, slavery was never legal. Neither the monarchy nor Parliament would ever attempt to authorize the writing of a slave code for the colonies, as Louis XIV had with the Code Noir of 1865. Parliament would never pass a law, as France did in 1716, to specifically allow masters to bring slaves to the metropolis. However, the British courts did recognize the status of slaves in the colonies and use common law and commercial law concepts to enforce sales contracts or marine insurance policies involving the buying, selling, and shipment of African slaves. But at no time would Parliament, the Crown, or the courts ever create laws or precedents to allow slavery in the metropolis or to govern slavery in the colonies. Slavery in the British Empire would be governed by local laws, haphazardly passed by colonial legislatures or developed by colonial courts responding to specific events and cases. This would lead to a complicated legal structure for slavery in the colonies and later in an independent United States of America. In 1619, in what would later become part of the United States, Dutch traders sold about 20 Africans to Virginia authorities. At the time, this was England's only New World colony. Virginia was the first British mainland colony to establish slavery, and the rules developed there eventually spread to the other mainland colonies. Virginia would become the largest British colony and the most important of the 13 that would eventually come to form the United States. From the 17th century until the United States Civil War, Virginia continued to maintain the largest slave population on the North American continent. The first Africans in Virginia were treated as indentured servants, held for a term of years and then eligible for freedom. Antonio, a Negro, came to Virginia in 1621 and was listed as a servant. He later became free, changed his name to Anthony Johnson, and ultimately accumulated land, held whites as indentured servants, and would later own a black slave. The earliest legal records of Virginia illustrate a confusing process. Some Africans were held in lifetime servitude, others were free. In 1640, John Punch was famously sentenced to a lifetime servitude for running away, while the same year, less famously, another African received no additional service for running away. By contrast, no European was ever sentenced to lifetime servitude for running away. Punch's case indicates that by 1640, the leaders of Virginia viewed Africans as enslavable and were gradually and inconsistently imposing that status upon them. This process was slow until the legislature began to codify slavery and give masters security in their ownership of slaves. A decision a year after John Punch was sentenced to lifetime servitude illustrates the haphazard nature of slavery at this time. In 1641, the General Court allowed John Groweer, a Negro servant unto William Evans, to purchase the freedom of his son, who was born to a black woman belonging to Lieutenant Robert Shepherd, another planter. Whether Groweer was a slave or an indentured servant is unclear, as is the status of the woman who bore his child, but the status of the child was unambiguous. After Groweer did for his said child purchase its freedom, the court ordered that the child shall be free. The uncertain status of Africans in early Virginia continued into the 1670s. Thus, in 1672, the Virginia General Court determined that Edward Mozingo, a Negro man, had been and was an apprentice by indenture, had served out his indenture, and thus the court ordered the said Edward Mozingo be and remain free to all intents and purposes. A year later, the court ruled that Andrew Moore, a servant Negro, had served out his indenture and would henceforth be free from his said master. Wonder why it says "be" with two E's. And that his master had to give him freedom dues of corn and clothes according to the custom of the country, and 400 pounds of tobacco. These and other scattered court records illustrate that the status of Africans was uncertain in early British Virginia. The rules were unclear, and there was no certain definition of who was a slave. In the 1640s, before slavery had emerged as an institution in Virginia, the colonial legislature, the House of Burgesses, tackled complex questions of servitude and status. The House of Burgesses was elected by the landowners and dominated by the emerging planter class. Their legislation reflected their class interest in controlling the colony's laborers, white and black. From the 1640s through the 1680s, the Burgesses struggled to secure their growing investment in Africans, but at no time was the legislature able to create a certain and clear definition of slaves. The Militia Act of 1639-40 recognized the colony's growing African population, but did not treat them as slaves. This act required that all white males, including servants, be provided with arms for militia service. However, the law exempted Negroes from this mandatory rule. The law did not preclude arming blacks to help defend against Indian attacks, but simply did not require it. This law may have reflected the fear of arming Africans who were in Virginia against their will and presumptively hostile to those who controlled their labor. 3 years later, the Burgesses adopted legislation to treat African females as tithables, just as European and African men were treated. Tithes were taxes levied on people, not property, who contributed to the economy. European women had not been tithable because the law presumed they worked inside the home and were not producing wealth. This law, by contrast, assumed that African women worked in the fields, alongside men of various races, and thus were tithables. This may have been an example of race discrimination, but more likely it was simply recognition that African females were usually used as agricultural workers just as men were, and should be taxed accordingly. This analysis is supported by subsequent legislation 20 years later taxing white women servants at the same rate as male servants and black female servants if their common employment is working in the crop. Significantly, the law of taxing African women as well as African men did not see Africans as property, but rather as members of the community, just like white men of all classes, including both burgesses and indentured servants. A 1657 statute regulating runaways also illustrates the lack of any formal recognition of slavery before the 1660s. This law punished runaway servants, who were overwhelmingly European at this time, by extending their service and branding them. However, those statutes did not provide any particular rule for slaves. In the same legislative session, the burgesses regularized the length of service for servants brought into this colony without indentures or covenants to testify their agreements. The law provided that anyone under 16 years of age would serve until age 21, and anyone 16 and older would serve for just 4 years. This would have applied to almost all Africans brought into the colony, as well as many Europeans. Water break. I lost where I was at. Europeans. The burgesses clearly did not anticipate that they would soon be treating Africans as lifetime slaves rather than short-term servants. In 1659-60, a Virginia law recognized slavery for the first time, although without defining it. The law provided that if the said Dutch or other foreigners shall import any Negro slaves, they, the said Dutch or others, shall, for the tobacco really produced by the sale of the said Negro, pay only the impost of 2 shillings per hogshead, the like being paid by our own nation. By this time, slaves were seen as commodities being imported into the colony. This was the first clear statement that Africans in new British colonies were considered things or property rather than persons. But of course, Africans were persons, many of whom resisted their New World bondage, New World order. Most commonly, they ran away. This created a new problem. The standard punishment for runaway servants, as set out in the 1657 statute mentioned above, was whipping and sometimes branding, followed by additional time of service beyond their indenture. But a slave could never have additional service added to his bondage. Thus, in 1661, the burgesses passed its first police regulation of slaves, dealing with the problems of European indentured servants escaping with slaves. To discourage such interracial challenges to the regime, the law provided that Europeans would have to serve extra time for any slaves who ran away with them. The new law declared, in case any English servant shall run away in company of any Negroes who are incapable of making satisfaction by addition of a time, it is enacted that the English so running away in the company with them shall, at the time of service to their own masters expired, serve the masters of the said Negroes for their absence so long as they should have done by this act if they had not been slaves. Every Christian in company serving his proportion, and if the Negroes be lost or die in such time of their being run away, the Christian servants in company with them shall by proportion among them either pay 4,500 pounds of tobacco and cask, or 4 years' service for every Negro so lost or dead. Sow? Is that what that is? S-O-E? This law not only provided compensation for masters whose slaves ran away with whites, but also drove a wedge between African slaves and European servants. The colonial legislators hoped this law would discourage interracial cooperation and lead it fewer escapes. The law helped divide European servants and African slaves, strengthen planter power, and more firmly attach the chains of lifetime bondage to Africans in the emerging system of slavery. The law also unambiguously acknowledged and affirmed that some Negroes in Virginia were incapable of making satisfaction by addition of time because they were slaves. But despite this explicit acknowledgement of slavery in the colony, the law did not help define who could be a slave. In fact, the language of the statute confused the issue. The law initially referred to any English servant who might escape with any Negroes who were incapable of having time added to their servitude. This language implied that some Africans had this status, but that others did not have such a status. All Africans in the colony were clearly not slaves. While being a Negro was clearly a marker of being a slave, all Negroes were not slaves. The use of the term English was also unclear, since at the time there were white indentured servants who were Irish, Scottish, Dutch, and probably other nationalities as well, but the legislation surely applied to them. Further confusion comes from the use of the term Christian, providing that if a slave ran away with other servants, every Christian in company would serve extra time for the loss of the slave's time. This may have implied that Christians could not be slaves, and thus conversion might emancipate a slave. Or it may have implied that the non-Christian status of Africans justified their enslavement. It would take a few years for the Burgesses to clarify this. Before the Burgesses could deal with how religion helps define slavery, let me just get clear here. Weren't we hearing that the Burgesses were just these like industrial lords? So how did they become the law? Just because of their wealth, which would be logical. I just need to learn more about that. Before the Burgesses could deal with how religion helped to define slavery, the Virginia legislature, boy, there you go. Freedom through Jesus Christ. This is why I spit on the Bible. Everybody is connected to Father, Creator, and Mother Nature, and these people that think different are satanic slave masters, and they need to be destroyed utterly. How dare you claim to be God's chosen people? Fuck you. Punch you in the mouth. Virginia legislatures faced a more pressing problem: how to classify the offspring of white men and African women. Under English common law, a child, even one born out of wedlock, followed the status of the father. If this rule applied in the children of slaves, then the mixed race children of slave women would be born as free people. This would lead to the situation of slave mothers raising their freeborn children while also creating a class of free mixed race people. The leadership in Virginia was troubled by both of these possibilities. In addition, since these slave women would not have been legally married to the fathers of their children, their mixed race children would have been legally bastards. Under existing law, how about fuck law? How about I'm done reading this? Because people that own a lot of money and property create law, and they create Bibles and constitutions and all these stupid ass schemes like cryptocurrency and smartphones to enslave us. So that's as much respect as I wish to give at this time to these bullshit ideas that everybody else believes in. So I'll make this document available in the description, and I appreciate Clint for pointing out to the pussy patriots that they're full of shit, just like the Christians that have no idea of what they're even talking about when they talk about their holy books. Good day.